Okay, here today with Michael Adamson from Frigo Adamson, solicitors at Robina. Good morning, Michael. How are you?
Good morning, Drew. Very well, thank you.
Thank you for joining us. Michael, I'll get you to touch on your background, but you've had a vast experience in business sales, commercial law, property law. Do you want to tell us a little bit about your background and Frigo Adamson?
Yeah, by all means. So our firm is a boutique firm with a particular emphasis on commercial business and property, as well as general litigation services. So we're a two-partner firm. My partner's the litigation specialist, and I otherwise focus predominantly on business sales, commercial corporations, and property law type matters.
Yeah, okay. All right, fantastic. Well, I guess we'll start off with a few basics. So what I wanted to run through today is a bit of a basic checklist on a few items that business people should consider if they're looking to put their business on the market. And I guess the first one of those that we'll touch on is the structure of that, whether it's best to do a straight out business sale or whether perhaps it's better to do a company sale or a share sale agreement. And you can draft contracts in either of those respects, but you can also provide some advice into which avenue would probably be the best one to take there.
Yeah, quite right, Drew. I mean, the key to any transaction from a commercial perspective is doing a bunch of legwork up front before you put the subject matter to market. Now, in some cases, what might suit you as a seller from a tax effective perspective might not necessarily be appealing to the buyer's market. So when we look at structuring a transaction, it'll be looking at both sides of the coin to ensure that a whole lot of effort's not going to be put into something that might not necessarily ultimately appear a buyer, depending upon the nature of the business being sold. But I mean, first and foremost, it would be important for me to triangulate with the client's accountant to understand what the motivations are in the exit, what kind of tax strategies basically in place to minimise tax implications that arise from the sale, and then equally explore any opportunities that might exist for that to be presented in such a way that might be equally enticing to the buyer. Mm-hmm. So structure is one of those fundamentals, Drew, that very much needs a fair bit of thought up front, and it's an issue that probably involves some good collaborative conversation between both the client and the legal advisor, as well as the client's tax advisor.
Okay, and particularly in this climate, I guess people are coming to us, their business, sometimes they're going well, sometimes they're not, sometimes they're closed down. And a question that we get quite often is whether or not the business is a going concern. Can you give them some advice on that and explain quickly what the difference is between something that's a going concern and something that isn't?
Yeah, so I mean, if the business can be properly classified as a going concern, that will be appealing to a buyer for one sole reason, and that reason is that the property is GST free. So if a buyer's marshalling a certain amount of money to acquire a business, the going concern exemption will help their cash flow. So the going concern only applies with a business sale. If it's a share sale, shares are not subject to any GST consideration. So the test that needs to be satisfied to get the going concern exemption is that all of the things that are required for the continued operation of the enterprise need to be supplied to an entity that will be registered on the settlement date. Now, there's actually a really useful GST ruling that's been published by the ATO that's a bit of a Bible for both legal and tax practitioners, with some really fairly useful examples. And importantly, there's a number of good rulings and fact backgrounds that actually constitute an enterprise in circumstances where at first blush you might not think that's necessarily so.
Yes.
So as I say, it's probably important to have a look at that issue fairly early in case there is anything that can be done from a structural perspective to be able to offer the going concern exemption, because it will be attractive from a buyer's perspective.
Okay. I want to, I want to now talk a little bit about leases, commercial leases, because I don't think a lot of business owners understand this clearly. Without a strong lease in place, if you are leasing a premise, if it perhaps isn't registered or doesn't have the options on it, it really inhibits, your chance of really getting a good price for that business. So do you want to just quickly explain a little bit about registering commercial leases and why that's important?
Yeah. So basically, the chief reason why you register a lease is to ensure that any buyer of the business is protected when they exercise their option. It makes the lease, the legal term is indefeasible. The risk is that if a lease is not registered and the owner of the freehold were to sell the underlying land interest, the new owner of the land is not bound by any options that sit within the lease unless the lease is registered. So that's a fairly significant risk from a security of tenure perspective.
That's very,
So
yeah, okay.
yeah, so basically, I'd also highlight that, most buyers, when they engage our firm for advice, it's one of the salient features of any business that a buyer is going to look at.
Yes,
So if a vendor is going to present the business in the best possible light, the lease can actually be a selling point.
yeah,
One, you want to present it so that there's good security of tenure, and then ideally as well, you want to present the commercial terms in the best possible light. Now, if the business has sort of been tracking along for a number of years and maybe exercised an option, again, there might be an opportunity to negotiate a position with a landlord to tack some other options onto a registered lease, which again will just remove any concern from the buyer's perspective. Again, just a really important preparatory step. So, like all things with the lease, in the whole, the question that a seller should be asking themselves is, am I presenting the lease in the best possible light? And if not, what steps can be taken in a time-efficient manner to alter the terms of the lease so that you can preempt the kind of issues that an inquiring buyer is going to make, and then address them before those questions get asked. As I say, the mindset should be that the lease should be a selling point, in my view, Drew.
yeah. Well,
And
it's one of the assets, isn't it? Really, it's your strength of ongoing tenure, really.
yeah, 10 years, everything. Certainty is everything. Predictability, and then just understanding. And again, likewise, in some businesses, if it's captured by the retail shop leases, there's some inherent benefits that flow. But if the lease, for instance, sits outside that statutory regime, there may be some other points that a vendor might be able to consider talking to their landlord about to present the lease in the best possible terms.
Okay, and I guess along the same lines, any licenses or permits that the business may need to operate are very similarly valued. If they need perhaps a food council inspection or a food preparation license or liquor license or any other sort of license, those really have to be in place prior to going to the market, don't they? And make sure they're updated and all ticked off.
Yeah, absolutely. So, and in some cases, an inquiring buyer in their due diligence period, might use that opportunity to actually test compliance with the terms of the license. So you mentioned the food license, for instance, Drew. There is a search that an inquiring buyer can undertake with counsel that triggers a health inspection. So to ensure that no adverse findings come back as a consequence of that report, again, the proprietor of the business that's being sold should ensure they're on top of their food and hygiene obligations under the relevant legislation. And then equally with the liquor license, to ensure that that the terms of the license are otherwise being complied with.
Okay, it's interesting. I think I want to touch quickly now on plant and equipment. I've had a couple of scenarios lately whereby we're about to settle and the buyer's solicitor has found equipment on a PPSR register that hasn't been checked off, even though it was paid out perhaps years ago. It just hasn't been cleared and it prohibits the business from settling. Do you want to explain, some people don't even understand what the PPSR register is. Do you want to quickly explain what that is, and just important that we check through that prior to going to market, make sure everything is unencumbered and clear off that?
Yeah. So the PPSR acronym stands for the Personal Property Securities Register, and what it is a public register where any lender gets to record the security interest that they have in a piece of personal property. And personal property can include such things as machinery, plant, equipment, motor vehicles, any item of personality that is not real estate, which is basically anything that's not affixed permanently to a block of land. So, and this is often the case, Drew, that some people, when they actually conduct a search of the registrar, will find a bunch of security interests that are recorded against their entity that they had no idea about. And sometimes that happens through the course of just credit applications in the course of conducting their business, where might be supplied credit of, let's say 50 grand a month, and in return the particular supplier has what's called a charging clause in the standard terms and conditions of the credit supply arrangement. So off the back of signing that credit supply terms, that supplier would then record a security interest on the PPSR. So apart from signing that one form, the vendor of the business probably hasn't signed anything else and would be completely unaware that a security interest would be recorded. So in our view, it was a fairly important preparatory step to actually conduct a search of that register up front. The cost of the searches are, really cheap. It's only a couple of dollars per search. And you would normally search all entities that are associated with a vendor. So for instance, if it was a trust that was selling a business, you would search both the trust and the corporate trustee or the individual trustee in its own right, just in case there was any misrecording of the security interest. The problem is if you discover the security interest only fairly late in the transaction, most financiers or suppliers will have a lead time before they can make an assessment and then prepare the relevant discharge to record on the register, remove the interest. So any buyer who is acquiring an interest is not going to settle and pay the balance purchase monies until they're satisfied that they're going to get clear and unencumbered title to all the business assets that's being acquired. So the securities register at the end of the day is a very efficient, transparent way of getting a quick understanding of what encumbrances there might be on assets of the business. Just like anyone buying a motor vehicle, you want to make sure you're getting clear title. Again, you look on the same security register to ascertain whether there's any interest recorded.
Okay, well, thanks for that. And that's an important check, very important, because it can delay the sale, can certainly delay settlement if things like that crop up. We're talking about, I guess, skeletons in the closet and things of that nature that can pop up last minute. What about, let's talk about perhaps past litigation or perhaps problems that the business may have had in the past that are no longer a problem, that the buyer may see as an issue or a risk. Is it best to discuss those before going forward and certainly make sure we have a plan in place to combat those issues?
Yeah, indeed. And that kind of threshold question may ultimately dictate what the structure of the sale transaction is as well. Obviously, if it was a share sale and there were any threatened litigation, then that would very much be an issue that would preoccupy the mind of the buyer, because upon completion of the acquisition of the shares in the company, the buyer then is going to have to assume the responsibility for the future conduct of any litigation.
Yeah.
So
for that reason, buyer might do a business sale contract to set up a new company to avoid any risk on that behalf.
Yeah, indeed. So if it's a straight business sale or asset acquisition, then any liabilities that have accrued in the on the seller's watch, they become matters for the seller, and the buyer does not assume any risk of litigation as a consequence of any negligent act or omission that was committed by the seller of the business.
Okay. Look, one of the things I've noted, you've got a checklist here, which we will provide to everyone. And I think one of the most important parts of this is the transition control and the release of information, because many buyers will go into a stage of due diligence. Some will pass that stage and others will pull out at that stage. And I guess a bit of a worry for a lot of business owners is how much information to provide to make sure the due diligence can be done. And then when do they actually provide some of the more critical information, like the contacts with suppliers and customers, that sort of stuff they may not want to provide upfront until the due diligence is done in full, that sort of thing. Can you hold business owners' hand and give them that timeline and make sure that's done in an effective and safe sort of manner?
Yeah, I mean, it's a really good point, Drew. And I mean, what I'd probably say as a motherhood statement is there's no one size fits all approach to these kind of issues. And that can be for a range of things. A recent example I'll make mention of, some businesses will have key employees where the proprietors of the business simply don't want their key staff to know ahead of time the business is going to be sold. I mean, if there's any flight risk with those staff by telegraphing those things early. So, I mean, sometimes it's very much of a case of exploring a conversation with the seller as to what the key sensitivities are, whether that's people, external stakeholders, or what have you, and then actually tailoring a fairly bespoke approach to how the key sensitive data is managed through a due diligence process, and then transitioning to a completion when the buyer ultimately assumes the right to receive all that data. Key message is it's not a one size fits all approach, and it tailored depending upon the nature of the business and how the sensitivities need to be managed.
Okay, no, it's important, and a very important part of that transition process and making sure it's done confidentially is the timeline of that. So I think anyone that needs advice in that area, you're going to be a great piece of help to make sure that's scheduled appropriately. I want to tell you quickly, yesterday I was listing a hair salon for sale, and the owner asked me whether or not she would have to sign a restraint of trade. And I said, look, I would assume you certainly will do, particularly with a business like that, where if you sell your salon, the buyer will want to stop you from opening another one down the road because the clients will most likely just follow you down. Do you want to quickly explain, like that's nearly 100% part of business contracts these days, isn't it?
Yeah, and for good reason. A buyer wants to ensure that the money that they're paying for the goodwill of the business is going to be protected against the seller having seller's remorse and wanting to go back into to business a short period after completion. So the key issue with restraints of trade is that they must be reasonable. So the common law position is that restraints of trade are of no effect unless they are reasonable, both from a geographical perspective as well as from a time perspective. So oftentimes, Drew, that aspects of the restraint may be subject to negotiation in terms of duration and geographical effect. But most sellers should be aware that they should probably be on the front foot in framing up in their own mind what that restraint should look like. So again, that's a fairly key component of the initial advice they should be giving their advisor in terms of what their future plans are. And if it's the case that they're exiting a particular industry, then a strong restraint, again, can also be a fairly effective selling point from the buyer's perspective. So nothing to shy away from. And from the buyer's perspective, given that they're potentially going to be paying a good component of the purchase price on account of goodwill, they are entitled to take some reasonable steps to protect that goodwill via the restraint.
Yeah, it is very common these days, and people should expect it. So I think it's an important point to cross off. Look, Michael, I won't take up too much more of your time. Really appreciative of having you with us today. And you're happy for anyone to give you a call or drop in for a coffee? You're happy to give anyone sort of half an hour of your time to discuss, excuse me, any of these issues prior to going to the market? Obviously, if work needs to be done, it needs to be done. If it doesn't, that's fine.
Yeah, but by all means, Drew, it's just like anything. I mean, the success of a transaction is sometimes dictated by how effective some of the preparatory work is done prior to a sale. So, my view is that, our practice as a philosophy, early prevention is always better than cure. So, if there's anything that we can do at the outset of a transaction to enhance the prospects of a good transaction from the client seller's perspective, would only be too pleased to have that conversation up front.
All right. Well, look, thanks very much, Michael. Really appreciate your time. I'll put in your contact details below this video for anyone looking to sell their business. You're a great resource. It's certainly been a great help to us. I appreciate your time. Thanks again.
My pleasure. Thanks, Drew.
Thank you.